Y'all may be seated. I understand that the jury's reached a verdict. Is that correct?
Pardon me?
I said I understand y'all have reached a verdict.
We have.
All right. You have the verdict form with you?
I do.
Can you hand that to the bailiff, please?
I will.
Ask the clerk to publish the verdict.
In the Circuit Court of the 14th Judicial Circuit in Fort Bay County, Florida, case number 22-608CA, Zachary Young plaintiff versus Cable News Network Inc. defendant. Verdict form number 1. Do you find by the greater weight of the evidence that defendant CNN committed defamation per se against plaintiff Zachary Young? Yes. Number 2. Do you find by the greater weight of the evidence that defendant CNN committed defamation by implication against plaintiff Zachary Young? Yes. Number 3. What is the total amount of plaintiff Zachary Young's damages for both lost earnings in the past and for the loss of his earning capacity in the future, reduced by the amount that plaintiff could have earned from comparable employment? $4 million. Number 4, what is the total amount of plaintiff Zachary Young's damages for pain and suffering, mental anguish, inconvenience, injury to reputation, and loss of capacity for the enjoyment of life that he sustained in the past and that he has sustained for the future? $1 million. Number 5, do you find by clear and convincing evidence that punitive damages are warranted against defendant CNN? Yes. Date, January 17, 2025, signed by the foreperson.
Okay, yeah. All right. Juror 6, I take it since you were holding the verdict, were you the foreperson for the jury? Is that your jury's verdict?
Yes, it is.
All right. All right. Anything from the plaintiff?
No, Your Honor.
All right. Anything from the defense?
No, Your Honor.
All right. All right. Jurors, based upon that verdict, what that means is we need to proceed to phase 2 of the trial in this case. I didn't print them out, but let me pull them up real
Sorry,
quick.
Your Honor, I think I was supposed to stand up.
No,
wasn't I?
no, you're fine. You're good. All right. I've got some more instructions to give to you, and what we'll do is just based on the time at this point, we'll move into phase 2. We'll get some lunch brought in to allow you to take a break, have some lunch at the appropriate time when it gets here. But we'll start with the presentation of some of the evidence and testimony to you until that point in time. Okay? Are y'all good with that? All right. And I know since there was a restroom and stuff back there, y'all don't need a break or anything right at the moment, do you?
No, sir, but we closed the blind.
Again? we
Just
get
the
that.
front one.
Yeah, just front one is, that's okay.
Yeah, I'm gonna have the bailiff go grab are your notepads laying out there, or are they in the folders,
I
or?
think we left them all in there.
They're all laying out on the table.
Okay. Yeah, why don't y'all want to go back there and go grab your notes? I don't want the
Y'all want
bailiff
me just to grab them?
look at whatever your notes may be or anything.
I can grab them if,
Okay, if you want to do that, that'd be fine. Yeah, I'd rather just not have somebody that's outside the jury going and grabbing notes that are not contained in your folders. All right. And I guess real quick, since I forgot to ask this question beforehand, after I'd resolved the jury instruction issues last night, I think it was. I don't know. It's all blended together at this point. And the set that I had emailed to y'all, I think it was last night after we got done, was both sides good with the clean set of instructions that I emailed? Okay. Obviously subject to what we had talked about before, but in terms of what I'd ruled, y'all were good with the clean set that I'd done in accordance with that. All right. Yeah.
You don't have a pen, I brought an extra one.
All right. Everybody got their own notes back and got pens and ready to go? Okay. All right. I'll give you some instructions now, and we'll go ahead and start proceeding. Members of the jury, I'm now going to tell you about the rules of law that apply to determining whether punitive damages should be assessed, and if so, in what amount. When I finish with these instructions, the parties will present additional evidence. You should consider this additional evidence along with the evidence presented, and you should decide any disputed factual issues by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. You are to decide the amount of punitive damages, if any, to be assessed as punishment against the defendant. This amount would be in addition to the compensatory damages you have previously awarded. In making this determination, you should consider the following. A, the nature, extent, and degree of misconduct and the related circumstances, including the following. 1, whether the wrongful conduct was motivated solely by unreasonable financial gain. 2, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known by the defendant. 3, whether at the time of the loss, injury, or damage, the defendant had a specific intent to harm plaintiff, and the conduct of defendant did in fact harm plaintiff. And B, the financial resources of the defendant. However, you may not award an amount that would financially destroy the defendant. You may, in your discretion, decline to assess punitive damages. When determining the amount, if any, of punitive damages to be awarded, you may impose punitive damages to punish the defendant only for the specific conduct that you have concluded caused plaintiff harm. You may not award punitive damages to punish the defendant for anything other than the conduct that injured plaintiff. That is the law that you must follow in deciding the second phase of the case. In a moment, the attorneys will make brief opening statements to you, and then we'll call witnesses. When they are through, I will have a few final instructions about your deliberations. And like before, you're going to get a written set of these instructions to go back to you. All right, so Mr. Friedman, you want to do a brief opening? All right, Mr. Rush, okay.
May I proceed? Good morning. We're still in the morning. On behalf of both Mr. Young and our team, I want to say thank you. I know Zach feels heard in a way that he hasn't felt for over 3 years since the segment was played. And I can't tell you how much that means to both Zach and to our team. You've also decided how we felt that CNN's conduct in this case is deserving of punishment. That a message needed to be sent in some form to media that the conduct, hunting a man down because you don't agree with his ideals, is not okay. It's un-American. The only way we can send a message at this point is through a fine. It's by punishing CNN where it hurts, the bottom line. We're going to do our best to be brief today and to get our case presented very quickly. The law tells us that we cannot punish someone until we know how much they are worth. A $500,000 fine, $500,000 fine, it's nothing to a man like Bill Gates. His investments make him more than $13 million before he sits down for lunch at halfway through the day. To put it in perspective, a $500,000 fine to a man like Bill Gates is the equivalent to a $2 fine to an average person. So, to punish CNN, you need to know how much they are worth. To help you understand how much CNN is worth, we're going to call just two witnesses. You're going to see some tape from CNN CFO, where we asked him some questions about CNN's financials. And you're going to hear from our expert, our financial expert, who's specialized in reading company financials. And he's going to help you understand